Today we'll be discussing the various forms of solving civil disputes that fall outside the courts, also known as alternative dispute resolution, or ADR for short. ADR has recently become more prevalent due to a few factors. Let's take a look at them. Number one, the Ministry of Justice stated that the courts should be the last resort for people involved in civil or family disputes. Number two, the use of ADR was encouraged in the Woolf Report. Number three, through the Civil Procedure Rules of 1999, a judge can stop court proceedings and encourage the parties to try ADR. ADR has various forms, but we'll be focusing on the three most important forms. When ADR is offered as a method of solving a dispute, it is normally either arbitration, mediation, or the ombudsman scheme that is being considered. Mediation. The first form is seen as informal method of dispute resolution. The parties are assisted in solving their dispute, rather than the dispute being settled through adjudication by a third party. The involved parties share the cost of mediation. Mediation can work in one of two ways. In the first, the parties are in separate rooms. The mediator, an independent third party, goes between the parties in the hope of finding common ground and a solution. This would be appropriate where the relationship between the parties has broken down to such an extent that being in the same room would be detrimental to the proceedings, or where one of the parties is uneasy about communicating directly with the other party. In the second, the parties are in the same room. Here the mediator's role is much the same as before. The mediator does not suggest a solution or give his opinion. He merely facilitates communication so the parties come to an agreement that they are both happy with. Conciliation is largely similar to mediation. The main difference lies in the conciliator's role being more interventionist, in that conciliator will go one step further and suggest possible solutions. Do note, however, that the term conciliation is not widely used nowadays, and conciliation is now generally regarded as a form of mediation. You should by now have an overall picture of mediation and an idea of how it works, what it is trying to achieve, and that mediation is becoming increasingly important in dispute resolution. You will need to show an understanding of the differences between the various types of mediation. But to help you gain the best mark in an exam, we need to look in more depth at the law surrounding mediation and the role that the courts and legislation play. Our starting point is to look at the court's duties under the Civil Procedure Rules. Under Part 1, subsection 4, the court's duty to manage cases, it is stated that active management includes encouraging the parties to use an alternative dispute resolution procedure if the court considers that appropriate, and facilitating the use of such procedure. Other important rules include Part 26, subsection 4. Here the parties or court can request that the matter is dealt with by ADR, as well as Part 44, subsection 3, subsection 5, where parties can be penalized on costs if a party insisted on a court hearing where a settlement by ADR would have been more appropriate. So, you just saw how Part 44, subsection 3, subsection 5 allows for the penalizing of parties who don't go through ADR when it would have been appropriate. Let's look at case law to examine this. The 2002 case of Dunnett versus Railtrack is our starting point. On appeal, Railtrack refused to accept Ms. Dunnett's invitation to settle matters out of court. Railtrack did go on to win the case, but were penalized on costs. Lord Justice Brooks went on to make an important observation in the case, stating that a mediator may be able to provide solutions which are beyond the powers of the court to provide. The case established an important principle, that is, if a party refuses mediation, an objective test will apply, and if satisfied, the refusing party will be penalized on costs. This objective test was applied in the case of Hurst versus Leeming, wherein it was held that refusing mediation would not also lead to cost-related penalties. This was because mediation would not have worked in such a case, as Hurst held an obsessive personality and was bent on the idea that he was a victim of injustice. The question now arises, can a party be compelled to use ADR? Well, let's refer to the case of Halsey versus Milton Keynes, General, NHS Trust, and find out. In the case, it was held that the courts cannot compel parties to use ADR. Lord Tyson in his statement said, "It is one thing to encourage the parties to agree to mediation, even to encourage them in the strongest terms. It is another to order them to do so. It seems to us that to oblige truly unwilling parties to refer their disputes to mediation would be to impose an unacceptable obstruction on their right of sex to the court. Arbitration is another prevalent form of ADR. It is commonly used by those in a commercial relationship, and unsurprisingly, it is now common to find an arbitration clause inserted in contracts. Proceedings are held in private, which is an advantage to those parties wishing to resolve their disputes confidentially. Although arbitration is the most formal of the ADR systems, it is quicker and more informal than litigation. This is mainly due to the lack of formal rules for evidence. The procedure of arbitration is seen as more inquisitorial than adversarial. Arbitration, like other forms of ADR, is seen as quicker and cheaper than the traditional court systems. The parties involved in arbitration can be legally represented and are more likely to continue their commercial relationship having gone through arbitration. So here's how it works. The parties to a dispute agree that a third party, the arbitrator, will resolve the dispute for them. The arbitrator may be an expert in his field, or he can be a lawyer. The arbitrator's decision is legally binding on both parties. It is therefore the most court-like procedure. Arbitration is based upon certain principles that are contained in Section 1 Arbitration Act of 1996. Do note, however, that arbitration allows for limited appeal routes. Having said that, let's come to the potential ombudsman scheme. The ombudsman role is to investigate complaints of maladministration. Initially, the ombudsman role was to investigate complaints of injustice resulting from maladministration by government departments. This was then expanded to cover any injustice or hardship caused by the National Health Service. The Parliamentary Commissioner Act 1967 does not define maladministration, but while the bill was being debated, the government spokesman Richard Crossman cited bias, neglect, inattention, delay, incompetence, inaptitude, arbitrariness as falling within the meaning of a maladministration. In 1993, the Ombudsman, Sir William Wright, expanded on Crossman's list, adding the likes of rudeness, unwillingness, bias, or misleading into the ambit of maladministration. We've talked lots about ADR and its theory. Let's briefly analyze it from a critical point of view. ADR allows for factors such as flexibility, informality, and speed. It is cost-effective and allows for the parties' confidentiality to be preserved, and that no one outside of the process will be aware of the proceedings. ADR generally gives the parties more of a say as to how their matters are to be handled and affords them with remedies and solutions that a court cannot. On the flip side, however, ADR depends on the equality of the involved third party to come to a reasonable solution. Forms of ADR such as mediation may suffer from a lack of legal expertise and enforcement problems, whereas forms such as arbitration offer limited appeal routes and may not necessarily be cheaper than going to court.